The social contract convinced groups of the notion that sovereignty could be achieved through contract and covenant ideology, starting of course with proto-state of nature arguments by stating everyone is by nature free of subjection by any government. Of course, these ideas were theories founded on Roman law, which stated a group of people can exist as a distinct legal entity. According to social contract theory, citizens have consented either explicitly or tacitly to surrender some of their freedoms, submitting to the sovereignty and the law of the government where they live in exchange for the protections of the rights they still possess. The question of nature and legal rights usually stem from the aspect of social contract theory. In these conditions, individuals are bound only by their own personal power and conscience. From this starting point, social contract theorists show in different ways why individuals would give up their natural personal freedoms for the privilege of political order. As time goes by, though, social contract theories are being replaced more and more by new concepts in politics, such as utilitarianism, Hegelianism, and Marxism. The Whigs, who believed in constitutional monarchy, stated, by founding government together on the consent of the people, suppose that there is a kind of original contract by which the subjects have tacitly reserved the power of resisting their sovereign. Whenever they find themselves aggrieved by that authority which they have for certain purposes voluntarily entrusted him. David Hume stated, "My intention here is not to exclude the consent of the people from being one just foundation of government where it has placed. It is surely the best and most sacred of any. I only contend that it has very seldom had a place in any degree, and never almost in its full extent, and that therefore some other foundation of government must also be admitted." State sovereignty consists of four aspects, which are territory, population, authority, and recognition. The term could also be understood in four different ways. Domestic sovereignty is actual control exercised by the authority within the state. Interdependent sovereignty is actual control over borders, assuming there are borders. International legal sovereignty is formally recognized by other sovereign states. Westphalian sovereignty is lack of other authority of state over domestic authority. Other authorities could be a non-domestic church, political organization, or any other external agent. Usually these aspects appear in the same place, yet not necessarily is it always the case. They are not affected by one another, but can be sovereign in one aspect and not in other aspects. Sovereignty is above all else more a matter of legitimacy, which requires recognition. A hypothetical trade in which two potentially conflicting sides exchange such recognition as the least costly strategy. The United States federal government, as well as the states, both have sovereign immunity. They cannot be sued without consent unless it has waived its immunity or consented to suit. Through the Federal Tort Claims Act, the government has waived its sovereign immunity to a limited extent. It waives immunity if the tortious act of the federal employee causes damage. The Tucker Act waives immunity over claims that the federal government is a party of. The United States government is immune to suit unless they consent to the suit. When they do consent to the liability of the suit, cannot extend further than the plain language of the statute authorizing it. The 11th Amendment does not stand for what it says, but for the supposition of the constitutional or the Constitution structure which it confirms. The state entered the federal system with their sovereign intact. That the judicial authority in Article 3 is limited by this sovereignty. The state, therefore, is not subject to suit unless by consent either expressly or in the plan of convention. Law in the United States derives from constitutional law, statutory law, treaties, administrative regulations, common law, as well as case law. If a statute is considered unconstitutional, that statute doesn't merely disappear automatically. It must be deleted with a new statute to take its place. Many states and federal statutes that have been declared unconstitutional still remain on the books for decades since. Under the principle of stare decisis, it is assumed that no lower court would attempt to enforce an unconstitutional statute. If a court does try to enforce these statutes, then the Supreme Court would step in and overturn the decision. The concept in turn goes for any court that doesn't enforce a statute that is constitutional as well. The United States Code is the codification and compilation of permanent and general federal statutes. Some of the statutes give the executive branch power to create regulations published in the Federal Register and codified into the Code of Federal Regulations. Regulations carry the force of law under the Chevron doctrine. All states have a legislation which enacts statutes and executive branch that publicly declares in a formal and official manner regulations that are in accordance with the statutes. A judicial branch that applies, interprets, and sometimes overturns statutes and regulations from the executive and legislative branches. This also applies to ordinances within the state too. State government obtains plenary power to cover laws that aren't replaced by the federal Constitution and federal statutes or international treaties that aren't approved by the federal Senate. Although Congress under Article 1, Section 8, Clause 3 has plenary power over interstate commerce, that doesn't preclude states from passing laws which affect interstate commerce also. This is known as the Dormant Commerce Clause. State laws have not really conformed together in the United States since its independence. Instead, it has gone in different directions to the point where the United States cannot consider itself as one legal system. It is actually 50 separate systems of tort, family property, contract, and criminal laws. The concept of plenary sovereignty is unlimited authority or control over other circumstances such as public funds, collateral, and legal claims. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. The person was originally referred to as a mask worn by actors on a stage. A person is a being such as a human with capacities and attributes consistent with personhood. Personhood is defined in different ways by different authors, disciplines, cultures, times, and places. According to jurisprudence, a natural person is a human, and in many cases, human rights are granted only to the natural person. The legal person is only the concept that a corporation can be recognized as an individual in the eyes of the law. This holds the recognition that corporations as a group of people also have rights and can exercise those rights under common law and the Constitution. Apart from officers, directors, employees, and shareholders, legal personhood doesn't hold that corporations are flesh and blood. It also doesn't grant corporations all of the rights of citizens either. In 1819, the U.S. Supreme Court ruled in Dartmouth College versus Woodward that corporations have the same rights as natural persons to enforce contracts writing. The opinion of the court, after mature deliberation, is that this corporation charter is a contract, the obligation of which cannot be impaired without violating the Constitution of the United States. This opinion appears to us to be equally supported by reason and by the former decisions of this court. In Santa Clara County versus Southern Pacific Railroad, the court reporter Bancroft Davis noted in the headnote to the opinion that Chief Justice Morrison Waite began oral arguments by stating, "The court does not wish to hear argument on the question whether the provision in the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protections of the laws, applies to these corporations. We are all of the opinion that it does, in part based on the principle that legal persons are simply organizations of natural persons, and in part based on the history of statutory interpretation of the word person. The U.S. Supreme Court has repeatedly held that certain constitutional rights protect legal persons, like corporations and other organizations. The court clearly affirmed the doctrine, holding under the designation of person there is no doubt that a private corporation is included in the 14th Amendment. Such corporations are merely associations of individuals united for a special purpose and permitted to do business under a particular name and have a succession of members without dissolution. The doctrine has been reaffirmed by the court many times since, and as a result of the First Amendment, Congress may not make a law restricting the free speech of a corporation, political action group, or the coverage of a local newspaper. Because of the Due Process Clause, a state government may not take the property of a corporation without using due process of the law and providing just compensation. These protections apply to all legal entities, not just corporations. In the 19th Amendment of the United States Constitution, a person cannot be denied the right to vote based on gender. A natural person can also hold office where a corporation cannot. A corporation can sue or be sued, own property, and both corporation and natural person are capable of committing crimes. A legal person is a private business, entity, corporation, or public government organization. The term person may also include any human or non-human agent that possesses continuous consciousness over time. A person is able to frame a picture of the world, formulate plans, and have the ability to act on them. The person is controversial in philosophy and law because it is closely tied to the topic of citizenship, equality, and liberty. According to law, only natural and legal persons have rights protecting privilege, responsibility, and liability within a sovereignty. Depending on the context, theory, or definition, the category of person may also include non-human entities, animals, artificial intelligence, legal entities, corporations, sovereign states, or any political entity, and estates in probate. The category may also include some humans with mental impairment, and it already includes pregnancies that are in prenatal development. Plaintiffs in a Planned Parenthood case attempted to ask the court to render judgment upon the substance of interveners' initiatives and its constitutionality in advance of an election taking place on the subject. Justice Randy G. Pierce wrote, "This court is without power to interfere with pre-election proposals because to do so may place the administration of government at the footstool of the judiciary. This court will exercise judicial restraint and follow the reasoning of the majority of courts throughout the United States, both federal and state, which have articulated a policy of deference towards direct legislation processes. We cannot invade the territory of the legislature or the electorate to review the substantive validity of a proposed initiative, and thereby we will honor the maxim embodied in the constitutional mandate of separation of powers." Personal identity is problematic because of two issues: the diachronic problem and the synchronic problem. The diachronic problem is the conditions of which a person at one time is still the same person at another time, thereby persisting through time. The synchronic problem is what features and traits characterize a person at a given time. Proposed solutions are continuity of the body, mind and soul, consciousness or memory, personality after death, and the bundle theory of self. The proposal that there are actually no persons or self that persists over time is also an option. According to Black's Law Dictionary, a person is, in general usage, a human being, i.e. natural person, though by statute term may include a firm, labor organization, partnerships, associations, corporations, legal representatives, trustees in bankruptcy, or receivers. To have legal personality means to be capable of having legal rights and duties within a certain legal system, such as to enter into contracts, sue, and be sued. Legal personality is a prerequisite to legal capacity, the ability of any legal person to amend, enter into, transfer, etc., rights and obligations. In international law, consequently, legal personality is a prerequisite for an international organization to be able to sign international treaties in its own name. Legal persons, Latin persona iuris, are of two kinds: natural persons, people, and juridical persons, also called juristic or artificial or fictitious persons. Lat. persona ficta. Groups of people such as corporations, which are treated by law as if they were persons, while people acquire legal personhood when they are born. Judicial persons do so when they are incorporated in accordance with law. Today, in statutory and corporate law, certain social structures are legally considered persons. In many jurisdictions, some corporations and other legal entities are considered legal persons with standing to sue or be sued in court. This is known as legal or corporate personhood. H.G. Frankfurt writes that what philosophers have lately come to accept as analysis of the concept of a person is not actually analysis of the concept at all. He suggests that the concept of a person is intimately connected to free will, and describes the structure of human volition according to first and second order desires. Besides wanting and choosing and being moved to do this or that, humans may also want to have or not to have certain desires and motives. They are capable of wanting to be different in their preferences and purposes from what they are. Many animals appear to have the capacity for what I shall call first order desires, or desires of the first order, which are simply desires to do or not to do one thing or another. No animal other than human, however, appears to have the capability for reflection, self-evaluation, that is manifested in the formation of second order desires. A person is recognized by law as such, not because they are humans, but because rights and duties are ascribed to them. The person is the legal subject or substance of what the rights and duties are attributed. An individual human being having such attributes is what lawyers call a natural person.